Yes, Mrs. Scott.
Good afternoon. Ladies and Lord, may I turn to the issue of familiarity and to the assertion in the appellant's case that familiarity is not enough. And in my submission, there are two issues which the appellant faces in relation to that proposition. The first is it has to be reconciled with what is the accepted position in relation to who may offer social support, and it's already been referred to, and so I don't need to labour it. But it's in the consultation document at tab 23, at page MS 814, paragraph 5.104, where there was concern expressed about the definition of social support potentially excluding friends and family, and the assertion was made this is not the case. We recognise the importance of friends and family, and that is why our definition of social support is support from a person trained or experienced in assisting people to engage in social situations. By referring to experience, we mean both people such as friends and family who know the individual well and can offer support, or those who do not know them but are more generally used to providing social support for individuals with health conditions or impairments. And so there is express inclusion of familiars as people who may be able to provide social support because of experience. And that, I understand, is not something upon which there is any intention to renege. And of course, it's not just people generally, but it's this person, this claimant, this applicant. And second, the concern on this part of the case from the respondent that if the court were to endorse the statement familiarity is not enough, there would then be a serious possibility of confusion. And I would respectfully question whether it needs to be said at all, because a member of the family or friend of a claimant who recognises the problem but doesn't know what to do about it is not going to be in a position to provide social support. But, and if I might respectfully adopt Lord Kerr's phrase, if by dint of familiarity, was I think the way that Lord Kerr framed it, a family or friend knows what to do, then of course they're in a position to provide social support. And so the example here perhaps might be the respondent's partner, who knows the triggers which will cause him to experience acute distress or panic as a result of her familiarity with him. And she knows then that she has to redirect the conversation or extract him from the engagement. And the anxiety would be that her familiarity might be labelled as such if the appellant's submission is accepted, and might be used to disqualify him in his needs from satisfying activity 9C. He needs someone with her experience of helping him in order to engage. And if I might also then go to my old friend's example of the autistic child, who is not able to receive help from anyone other than perhaps his mother. To dismiss the mother as unable to qualify, or him as unable to qualify because he needs his mother because she's familiar, and that's what's necessary to allow him to receive the help, would be to disqualify him from receiving the descriptor, the expression of descriptor in 9C, which he quite clearly needs. It's not a matter of choice, it's a function of disability.
I didn't think Miss Broadfoot was disqualifying the mother in that
No, I know.
example. I thought she gave it as an example to show how
yes,
the mother would qualify.
Indeed, and I'm saying, well, if one takes that example, one can generalise from it back into somebody who has a mental health difficulty of a different nature, and therefore needs the familiar person, the trusted familiar person, to give the help that is needed. And the focus is, of course, on the person's need, not the availability of the help.
But if the government accepts that familiarity, i.e. family and friends, combined with the consequence of that familiarity, i.e. the needed help, is what's involved, then you don't take issue with that. It's the absence of the by dint of, which Lord Kerr's spoken of, that is your concern. Is that right?
The concern is that if one takes the statement of the case at face value and says familiarity is not enough, one could easily get into problems where tribunals and decision makers refuse to apply the descriptor. It's important one looks underneath and say, do we have somebody who needs the support from somebody experienced who's able to provide that help? Finally, under this heading, for the respondent, we share Mind's concern about the proposed insertion of by reason of, and agree that that is otiose and liable to confuse. It does not feature in the regulation. It distracts from the straightforward statement of the test, but as that is really Mr. Drabble's point, I will leave that to him to explain further. And that takes me to the timing issue. And what is said on behalf of the respondent in relation to that is it's a matter for the court whether my ladies and my lords accede to Mind's invitation not to decide the timing issue. For the respondent, the concern about the prospect of constraining the test as the appellant seeks when there's little empirical information is well understood. On the other hand, it is the appellant who proposes the constraint, and it's a constraint that was rejected by the inner house of the Court of Session. And the court here may form the view that the Court of Session was right, and the timing constraint cannot be justified, in which event it may be appropriate to dispatch the proposition now rather than wait for the next case. But obviously this is a matter that's in the court's hands. For the respondent, it said that the basic issue of whether the court can be persuaded that a descriptor in activity 9C should be subject to a limitation that doesn't appear in the plain terms of the regulation is the issue. And in relation to that, I stressed in opening the breadth of the potential engagement as it appears in the final version of the regulations. It does, of course, cover a wide variety of interactions, and as Lord Glennie points out at paragraph 39 of the Court of Session's opinion, the engagement may be one-to-one. And indeed, if one's looking at social inclusion, a person who has a difficulty should not be precluded from one-to-one engagement, potentially romantic or sexual engagement, and may require help and support in undertaking that engagement. And it should be uncontentious that social inclusion should encompass that. And that is one reason why, in respectful submission of the respondent, the appellant cannot be right. One could develop this a little further and say that it's quite obvious in ordinary life that help is regularly provided in advance and otherwise than when physically present. One could take a sporting analogy. For example, in the game of football, the manager is not on the pitch with the players. They have to engage in the game themselves. But nonetheless, the skill and experience of the Ole Gunnar Solskjaer is important. And the experience and skills of Ivan Lendl, who's not on the tennis court with Andy Murray, is important. And if one takes just that example as a form of ordinary experience, then one could see that somebody in the position of the respondent may well require help, skilled help, in advance of an engagement. And one can take the particular example here that although his partner is regularly with him in engagements, she does do a lot of work preparing him in advance. She sits him down and goes through the worst case scenarios, and that's a technique she learned from a community psychiatric nurse who was regularly engaged in that, and she knows of people who receive that sort of help from a community psychiatric nurse who's not directly involved in the engagement. And one of the concerns the court may have about this aspect of the appellant's case is that it actually robs the trained help of much of its content. And if one's looking at a functional calibration of a person's disabilities, the more disabled they are, the more skilled or trained the help might have to be. And if they're so disabled that they need the assistance of cognitive behavioural therapy or some other form of therapy, their therapist is unlikely to be with them in the course of the engagement. And all that my learned friend could say was, well, maybe a social worker or maybe a nurse. But how often will that happen? And one's looking at social inclusion, which would involve engagement, one hopes, every day of a person's life. And therefore to exclude all help under Activity 9C, which is not physically present for at least part of this engagement, is to rob the activity of much of its force in terms of social inclusion. The appellant complains that it might be difficult to determine a time frame, and the response from the Court of Session was this was a question of fact and degree. And in the respectful submission of the respondent, it really is not so difficult. It shouldn't be difficult in relation to contemporaneous support that doesn't involve physical presence. The difficulty just doesn't apply there. Most examples of advanced support are of help given immediately before the engagement or in the period shortly before the engagement. And the Court of Session had the answer when they pointed out that the descriptor refers to needs social support in the present tense. That's in paragraph 49 of the Court's opinion. But in any event, if one's looking at applying this descriptor, one's looking at needs in the present tense over a period of a year, 3 months before the date that's relevant for the prescribed date for the claim and 9 months after. And for the respondent, it's submitted it's not significantly more difficult to ask the question in relation to help at the time of engagement than help in anticipation of the engagement. For example, how long is this claimant expected to need CBT to help him engage? For how long will the claimant need her community psychiatric nurse to go over with her what is to be expected in her coming engagements in the next week or so? And for how long will the claimant be in a position of this immediate need? They're all questions of fact and degree which decision makers and tribunals should be well placed to answer. The appellant expresses concern that allowing for help other than the course of engagement will lead to arbitrary decision-making. For the respondent, it's submitted that excluding help other than the course of engagement will lead to arbitrary decision-making, because if one needs help, and this is a calibration of functional disability, that part of help will be important, and it's not excluded by the regulation. So for that reason as well, it's submitted for the respondent that one comes back to the clear and straightforward question: does this claimant need help from a person with training or experience to be able to engage with other people? And that is the answer in submission of the respondent to the timing issue as well as the qualitative issue. And unless I can assist my ladies and my lords further, those are my submissions.
No, thank you very much indeed, Mrs. Scott. Thank you. Mr. Bright? Mr. Draven.
My ladies and my lords, I propose to make submissions just on the qualitative issue, and fundamentally not in relation to the criteria, the construction of the words in play in the descriptor, or submissions of that sort. Simply an attempt to place, from Mind's perspective, the issues in the context of the practical decision-making which needs to follow. Because Mind is anxious, together with the respondent, that the test that falls to be applied as a result of this case is simple and readily understood, both by first instance decision makers at the level below the first tier tribunal, and capable of catching the actual experience of the claimants as the claimants are capable of articulating it to the decision maker. So the reason we want to keep the test simple is twofold. First of all, we say that the simplicity of the test articulated by the respondent and us follows from the wording of the descriptor. That's the construction point about which I shall say little more. And the second is, as I say, the practical interface between the claimant and the decision-making process. We have tried to grapple with this in the witness statement of Vicky Nash, which the court may have seen starts at MS 52. Tries to put in words the sort of issues that will be faced by first instance decision makers and the FTT. So if I can ask the court to look at MS 59, there's a series of paragraphs running from 30 through to 34, which were drafted at a time before the Secretary of State's change of position. So it's probably fair to say the primary target of these paragraphs is whether or not the social support descriptor, whether or not counselling, whether or not prompting constituted social support for the purposes of the social support descriptor. But a lot of the points, the practical points that are made in paragraphs 30 and 31 through to 33 apply now as to why it is that we say the court should not place any additional gloss on the simple test that's created by the application of the statutory words. And what we say in paragraph 31 is two preliminary points. First, the people that we spoke to, advisors and individuals, did not naturally describe the support that they receive in the level of detail that would allow assessment of whether it was reminding, encouraging or explaining. They would instead say things like, can't go anywhere without my partner, or I need someone to take me to appointments. It took a significant amount of probing and clarifying to elicit what exactly the person supporting them was doing. If the difference between B and C was qualitative, in many cases it would be very difficult to assess on the information given whether the support a person is receiving falls within the prompting definition. And that last sentence is aimed to part of the debate which is now over. But the next paragraph is also important. Secondly, the language interviewees used varied significantly, with two people describing the same qualitative support in different ways. This will cause further difficulties if a qualitative difference is required, as the award given may be determined by the claimant's description rather than the need. For example, Kieran's son, I'll come back to Kieran in a moment, but Kieran's son required the constant presence of another person when engaging socially to avoid a risk of violence due to paranoia. He was awarded B. Kieran felt that the lower award was because he'd referred to a need for prompting in the claim. These points from our engagement reflect what we have heard more widely on PIP assessment across the activities. Criteria need to be workable in practice. They must be understandable and broad enough to capture the different ways in which people's health conditions can affect their daily life. Requiring people to relate their experiences in very specific, obscure and inflexible terms will mean that people will struggle to satisfy the descriptors. In this activity in particular, as set out below, even experienced advisors struggle to understand what decision makers require.
Mr. Can I just ask, is what's described in 32, is that reflective of the sort of problem that Ms. Scott told us about, that some tribunals were starting by saying, well, can this be described as prompting? And if it was, they treated that as categorically incapable of being social
somewhere
support.
in the rest, well, yes, sorry, I don't interrupt you. But yes, I mean, right. I think it's somewhere.
But it sounds as though the Secretary of State has moved away from that as an appropriate.
He certainly moved. He has certainly moved. She has certainly moved away from the position that there's a total distinction between prompting and social support on the one hand, but we are so that I completely accept that on the face of it, the danger of a tribunal getting as far as prompting and then stopping, which is what we have described as conceded to an extent. the point of this submission, the remaining point of the submission, is that if one instead looks for the Secretary of State's distinction between, say, familiarity on the one hand and social support being provided by someone experienced, one is in danger of creating a further trap, a search for further criteria. I'll try and make this good, and then we come to what the Secretary of State says. Search for further criteria, which is not required by the statutory wording. So that the direction that emanates from this court should either be the simple direction that the respondent and I have formulated. Practical content of our direction is the same as the respondents, I think, because we've got a bigger gloss on how you get there. Or alternatively, it should be in the context of a judgment which makes it plain that the sort of very commonplace examples we've tried to describe in the witness statement will be enough for the descriptor to be satisfied. That's the practical concern we have. And I'll try and make that good. Having got to paragraph 33, the deponent, Vicky Nash, goes on to describe various categories of help that family members in particular, that's what we've fundamentally focused on, family members or friends, are likely to provide. So that if, for example, one looks at the end of paragraph 35, Mr. Mandel is a welfare rights advisor, explained earlier in the witness statement. There's told us of a client who in the manic phase of her bipolar disorder struggled to keep a track of a conversation and needed reminding of the purpose of the interaction and what was previously said. Without this reminding, she was unable to engage successfully. And what's being described there is the ability of a family member, because he or she knows the claimant well, to provide the support that is required. Mine is plainly telling the court that that sort of relationship will often be described as I need to have someone I can trust, or I need to have someone with whom I'm familiar. But tucked into that concept is the need for practical help, use the word need advisedly, which comes from the experience of the long-term relationship, the real relationship, in-depth relationship between the claimant and the relative and the relevant relative. And if you look at the same point on paragraph 38, Vicky Nash describes how some interviewees required someone present to explain what was being said to them or help explaining themselves to others. Doris told us my words get muddled, and Francis that he had trouble explaining himself. For Kieran's son, due to his paranoia, there was a risk that he would misinterpret what someone was saying, which could lead to an escalating situation and potentially violence. Mr. Beer told him a similar client.
Again, unless I've got the wrong end of the stick, on my understanding of the Secretary of State's current position on this appeal, these cases would be within the regulation.
Yes, as I started out, I'm not so much concerned to establish the dividing line based on the construction of the regulations between myself and the Secretary of State. We are anxious to avoid is, come to the Secretary of State's printed case of what she actually says in a moment, to a situation in which the direction goes off looking for a distinction between help which qualifies and help which doesn't qualify, which is not required by the words, and which is going to be very difficult to apply in the sort of practical circumstances that are described by Vicky Nash.
Well, yours is really a simple formulation, is it not? That is, you identify the need,
Yep.
and then you look at the help, and if the help is addressing the need, that's all that's required.
Exactly. And so that if you, I mean, just to make it as prosaic as one possibly can, one has the sort of claimant who is being described in this witness statement, they have a relative, father, daughter, whatever it is, who on a day-to-day basis goes around with the claimant, they will have the experience because it's good enough that the experience comes from that sort of day-to-day contact. That satisfies the test. If the tribunal then start to say, well, is the experience, is the help coming from the mere fact that you're with a trusted relative, or on the other hand from someone who has the experience, then there's a danger of looking for a qualitative difference between the kinds of help which isn't justified by the regulation or by the description of the descriptor.
But the essential question is the help actually assisting?
Yes.
I mean, that's the essence of it, isn't it?
Yes. You apply the wording of the descriptor with the definition of social support, and you get an answer that if help from an experienced person is needed, that's the end of the question, and there's no need to go any further. In answer to my Lord Sale's point, it's not so much that the Secretary of State's test is wrong, it's that it's unnecessary and likely to confuse. I'll come back to the way in which it's actually formulated in the Secretary of State's case in a moment and try to make that good.
I'm just wondering, the examples given in paragraph 38,
Yeah.
wouldn't they fall within the activity of communicating verbally, activity 7, rather than engaging with people face to face? I mean, they might come within both.
They might come in both, yeah.
Yes, I'm worrying about the relationship between the two.
And I've thought more about Kieran than the other example.
Yes.
Kieran, it's quite like the respondent's example of watching for the trigger points. As I understand,
Yes, though his problems are different. Let's not confuse the two problems.
Let's say with Kieran, I'll show
Yes.
the lady the interview notes in a moment.
Yeah.
As I understand it, the father, that is Kieran, goes with son to various situations. He knows his son very well, if I can just put it like that. He's familiar, and he can spot when things are about to go wrong. Now, that's not just communicating verbally. It's a form of help or assistance which is necessary to make the social engagement successful, if I can put it like that. But it will be described as familiarity or prompting or whatever. Won't come out very easily out of an analysis that's targeted by the DMP at the claimant's own articulation of the point. That's the point. So that if one then goes on with this, having taken on board those list of examples, there's a section in the witness statement which starts at paragraphs 45, it goes from paragraph 44 through to 47, MS 63. And this is really targeted at what words the claimant is going to use to describe what help he or she gets from the relative. So that 44, many of the people we spoke to needed the support set out above to be provided by a particular person or group of people in order to be effective. Rather than referring to training or experience, however, many of the interviewees referred to trust or someone that they know well. And then A is Kieran, Kieran's son, more accurately. Kieran is saying his son needed someone he knew well and had built up a relationship and trust with. But that formula is being used to actually describe a situation in which various trigger points can be identified. Aisha just says, go to the shops with a trusted person. Doris needed someone she trusted, otherwise I won't tell them what my problem is. How will they be able to help? Now, tucked into that phrase is a situation where the person that she trusts has the experience of working with her, being with her in the social situations, which is precisely why Doris is able to say, otherwise I won't tell them what my problem is, how would they be able to help? It's the knowledge and the experience which feed back into a description which is described as trust. And then the same point about Francis, it's exactly the same point. And then there is a distinction which we accept in paragraphs 45 through to 47. 45, the witness statement says, as we set out in our consultation response to the assessment criteria, the support of family and friends is vitally important, and we were pleased the government clarified that informal support will count within the definition of trained or experienced. Trust and knowing someone well appear to be more natural ways of referring to the experience that a friend or family has, as these are built up over a course of support. The individuals we spoke to did not naturally refer to their partner, for example, being able to support them due to their experience. Then there's a contrast.
But what do we take out of this? Because we have to construe the words of the regulation, which talk about training or experience.
Yes, what you take out of it is the disadvantage of not simply applying to the word in the direction that emanates from the court the test that is produced by the wording of the descriptor, joined together with the definition of social support.
But I mean, if you look at the definition of social support on page 330,
Yeah.
it says it means support from a person trained or experienced in assisting people to engage in social situations.
Yes.
I mean, what's the point of referring to the training of the person or their experience if there isn't to be some connection between that and the assistance they're going to give the person?
I am not submitting I'm not submitting there's anything wrong with the approach of the inner house in the paragraph we've already looked at, which I think is paragraph 55, is it? 55. Yeah.
Yes.
I'm not submitting the approach is different from that, but we are reacting to a situation in which the Secretary of State has now accepted that prompting is a species of providing social support, suggests a different gloss. I'll come back to the different gloss as it's expressed in the printed case.
Well, there isn't, as I understand it, a huge gulf between the Inner House and paragraph 55 and the Secretary of State's position.
No.
There was a dispute about the end of paragraph
The last
55. Familiarity is the point that Mrs. Scott took us to, that familiarity by itself isn't enough. The government says it has to be familiarity which creates a certain type of help to meet the need that heading C is addressing. So, I mean, you're quite happy with what's said in 55?
Yes, I guess we are. I mean, we don't think there is any error of law in paragraph 55. What we resist, I keep saying I'll come to it, but what we resist is any further formulation that says that familiarity is not enough, because we think there is unless that's very carefully explained, capable of leading to a very genuine confusion, where a lot of situations where the help is being provided by someone experienced in the sense that's required by the descriptor is being described as simple familiarity and therefore put to one side. Now, this court is not going to do that, and so the dispute on the product of the wording is now very limited or non-existent. I agree with that.
Well, would it be addressed by just having a warning included that you need to look behind the words used by the claimant to find out what they really mean about what the person knows about them and what they do to help them?
Well, that would certainly help. I mean, our preferred formulation is to we simply stay with the wording of the. I mean, no doubt there will be a judgment explaining why it's sensible just to stay with the with the wording of the descriptor. But we would certainly say you need to unpack what the claimant is meaning by these very commonplace words like "I need someone I trust with me" or I go with my partner.
Well, those are the words the claimant's going to use.
Yes.
So it isn't actually an answer to that problem to say stick with the wording of the descriptor, because they're not going to use the words in the
No,
descriptor.
well, I just said that. Yeah. Yes. So you
You need to go behind the words they use.
yes. And I think there is a... can I just go, having promised, I'll come back to Kieran in a minute, but if your Ladyship and the rest of the Court will go to the Secretary of State's case, and it's paragraph 85 at MS 162. Secretary of State says, the inner house's approach confuses are liable to be applied by decision makers in a manner that risks confusion between the persons who require support from a person because of their relevant experience, which might include experience gained in the course of being friends or family, and those who require support from a friend or family member solely because of that relationship. The distinction is between those who need help from an experienced friend by reason of that helper's experience, albeit gained because of their relationship, rather than solely by reason of the claimant's relationship with the helper. Very common for a person to respond well, only respond well, to someone they know and trust. However, the need for help from someone familiar or trusted on its own does not turn prompting into social support. Now, the difficulties with the submissions in this, that there's nothing necessarily wrong with that, but it is looking for a distinction between the need for help from someone trusted on its own, need for help, so it's accepting on its face that help is needed, but it's not enough for them to be familiar or trusted. I mean, our point is that routinely, the relative in this sort of situation will be familiar or trusted because of a lengthy exposure to the experience. Now, one solution to that, I agree, would be to draft the judgment so that that came out on its face. But what we invite you not to do is to set up the dichotomy in paragraph 85, because it simply doesn't describe the situation in terms which tribunals or decision makers, let alone claimants, are going to find very easy to describe.
In the course of submissions, I put an alternative formulation, which I think that the Secretary of State accepted. Do you have problems with that?
Yes, we do, because I think your Ladyship referred to the type of support, as I recall the formulation.
Help of a kind.
Type or kind, I forgot which the word was. We don't think that's correct. You look at what help is needed, the need will be the same, whether it comes from a professional or from someone who's experienced. Just look at what is actually needed, that's the emphasis. If it's needed from an identified individual who does have the experience, our submission is that's the end of the case. You stop there. You don't go into inviting the tribunal to look at the dynamics of family relationships in order to see whether the help is needed from someone who they trust simply because of the family relationship, which is what 85 is essentially inviting one to do, or whether the help is needed because of the experience. We say the experience will very often be, well, almost always, implicit in the relationship of trust and confidence that is being described. So there is, I think, my submission is there is actually a different emphasis. So what paragraph 85 is trying to say is that in a common family situation where the help is being provided by someone who has known the claimant for years and who is trusted by them, that won't count unless you can find something else. And that is what we are quite concerned to resist. Are concerned to resist.
But you do accept that not only must you identify the need, but you must also show that the need is being met by the assistance that is being provided.
Well, in the situation that we're talking about, where you're dealing with family members, essentially family members or friends or whatever, that sort of an informal relationship, we accept, and our formulation in the direction accepts, that the need has to be for help from someone experienced in that way. End of story, though, if it is.
Yes. But the foundation is the need. And once you've established the need, then the experience of, it's not only the experience of the person who's supplying the assistance, but also presumably the experience of the person receiving the assistance. Because if you have a bond of trust with a father or a mother or whatever, that may well play into the receipt of assistance.
Yes, indeed. I mean, you are commonly likely, in the situations we're dealing with, to deal with a relationship between the two parties which has grown up over time. Our perspective is that will often demonstrate experience on the part of the person providing the help, and may explain why it is that the person being helped needs the help in that form. I don't have a problem with that. But what I'm asking the court to be very, very cautious about is drawing the sort of distinction that is drawn in paragraph 85, where between those who need help from an experienced friend or relation by reason of that helper's experience, rather than solely because of the claimant's relationship.
I mean, the relationship may be the foundation for the help. I mean, that may be the ingredient that actually supplies the help.
It will supply both the need for the help, or the reason why the need is satisfied by that form of help.
Yes.
And the relationship over time may indeed be the experience. It's not a dichotomy. The examples I was taking in the court too, before I diverted to paragraph 85 in our witness statement, show that it's perfectly possible to think of examples where help is provided by someone who is familiar, but where it's very obvious that the help doesn't need to come from someone who's familiar. We give the example of, I think it's of a mother who takes her son to the post office. Routinely, that's what happens. It might be grandmother, actually. But if she's not available, someone else does it. So that particular piece of help can be done by anybody, not the experienced person. But if you, the decision maker, find on the ground that the help is being provided by someone who knows the claimant well and who is trusted and whatever with them, then that will commonly be the end of the inquiry. So that is the basic submission. If we go back to Kieran, we're probably not adding anything now because we've probably done this sufficiently. If we go back to Kieran, the interview notes which form the input into the witness statement are MS 121. Your Lordship my ladies will see, picking it up halfway down the page.
MHPs are presumably mental health problems.
Yes. Yeah. I always struggle with that. That is what MHP is. And if you pick it up, a third of the way down the page, needs to be someone he knows well, needs to have trust, needs to have built up a relationship. Support, reminded the thing is coming up, encouraging so he doesn't, then presumably he should bail out, I imagine, but it doesn't. Speaking to, monitoring while there, watching to see if he gets anxious, if he is, would intervene and take him away, if not, might escalate to violence. And then there's the reference to why Kieran, Dad, thinks he only got 2 points and not 4 because of the reference to prompting. But this is just an example of a situation where the relationship will be described as trust, confidence, and so on. But that here, as in the respondent's case, it's fairly easy to pull down into the triggers, spotting when the social situation is going to degenerate. My additional point is it doesn't need to be as stark as that. If the support is coming because of the long-standing relationship, that is highly likely to be enough. Finally, those are essentially our submissions. If I can just draw your lordship's and my lady's attention to paragraph, so MS 115, we're dealing with 2 case studies which were exhibited from part of the consultation.
Tom and Elizabeth. Tom and Elizabeth.
Yes, well, your ladyship has got a point. There's Tom. The sole description of what Tom can do is in the first paragraph. He's able to communicate how he's feeling and what he needs to familiar people, though he needs support from someone familiar to engage socially. And then that's the sole description. That was enough in the consultation document. If the court, the lady and the other members of the court drop down to paragraph 8, you will see that the consultation material envisions that he will be awarded 4 points on the basis that he needs social support to engage socially. So needs support from someone familiar. Now we say that's entirely the correct approach on an understanding of the sort of factual situation where this will arise. That will normally be enough, and the tribunal should not be going off into a further inquiry about distinguishing between the need for support just because you're familiar and support because arising from the experience. It should just ask itself, is the support needed? The lady wants the same position. Unless there's anything else on which I can help, those are the submissions.
Yeah. That comes from which, was this the first consultation?
I've got a note, 16th of January 2012 is the date of the document. And there's a heading, indeed. Weston points out, the person in defendant's favour, second draft assessment criteria and consultation document. And then the date of it for the court's note is the 16th of January 2012.
Thank you.
So an odd submission from me in the sense that it's not a detailed submission on the wording of a social security regulation, it's simply a submission on the practical circumstances in which it falls to be applied.
Thank you very much indeed, Mr. Dreville. Thank you. Ms. Broadfoot, would you like a lectern?
Oh, yes, of course.
It's usually a bit more helpful.
If I can start then just with familiarity and trust. All we're saying is that familiarity and trust are not necessarily the same thing as experience. That's all. We all agree that the question is, does this individual need social support as defined? That is defined as support from a person who is trained or experienced. That's true. But repeating those words in a direction doesn't really help anybody. As Lady Black pointed out, where an individual makes the point to an assessor that they need X person to come with them and help, the assessor or the interviewer or the FTT must look behind the words and work out whether the support that's being provided falls into 9B or 9C. And the difference between the two, when all we're talking about is prompting, is the provider of the support, which is someone who is trained or experienced. And it must follow, and I'm not even sure this is actually in dispute, it must follow that, as we would say, as night follows day, that the reason that they need a trained or experienced person is because of their training or experience, not for some other reason. We had understood that to be, as a legal explanation or as a legal analysis, relatively uncontroversial. If you look at paragraph 22 of the respondent's case, MS 181, paragraph 22, the necessity for social support is related to the need of the claimant. And at the bottom, if there is a need from support from a trained or experienced person, the descriptor 9C applies. And the same is true in relation to the intervener. And that is MS page 196. Paragraph 21. And 23. There isn't actually a dispute about what we say. The dispute is whether or not you should give a legal direction that recognises that. Because there is potential for argument, it's submitted that you should make that clear in one place or another.
And that's what leads you to 91, your paragraph 91, B and C, is it?
S165.
Thank you. Yes.
So what is the fear that you're trying to eliminate? What is it is going to creep in if you don't have C?
That assessors and tribunals and those making decisions won't ask the right questions.
Yes, but what scenario is going to get a benefit that shouldn't be given to them if that paragraph isn't there? Can I have a practical example? What's it eliminating?
It's eliminating prompting. It's cases where people will respond or can engage only with somebody that they know, for example, but it could be any number of people that they know, and on its own, that might be just familiarity because there's nothing special or particularly experienced by the person who needs to give that kind of support. That person would have a lower level of need, and that should be reflected in where they most appropriately fit in the hierarchy. And then you've had my submission on familiarity, and the respondent, although she objects to the rider, it's clear from her paragraph 23 that they accept it as an accurate statement of the law, that familiarity on its own is not enough, and that's MS 181. Turning then to the broader point about things being complicated and that one should keep the system simple, obviously there is desire in simplicity, but there's a balance to be struck, and it's important to remember that the intended audience who have to apply the descriptors are the decision makers, the assessors, the tribunal. And just as I would not expect, for example, to know exactly what I needed if I went to the doctor, I would expect the doctor to ask me the right questions so as to understand what it was that was wrong with me and could prescribe what was required. And it's the same with this scheme. We expect the professionals to ask the right questions. Finally, under this heading,
Whom do they ask the questions of?
of the people seeking.
Claimants?
Yes, of the claimants, yes.
So they've got to be questions that the claimants will understand.
Yes. In relation to, very briefly, to the UN CRPD, the Convention on the Rights of People with Disabilities, the points haven't been pleaded in any detail in the written case, and in my submission, it has nothing to add in the present case at all. The UN CRPD has obviously not been incorporated into UK law and doesn't have direct effect even as an EU treaty because it's not sufficiently precise, clear and unequivocal. And there's a whole load of case law on all of this, but none of which has been drawn to your attention. So I would respectfully submit that it should be put to one side.
Is there any statement that we can find in some of the preparatory documents as to the overall aim of these definitions, these requirements, these conditions?
Do you mean the scheme, or do you mean something more specific than that?
Well, probably the scheme.
Yes. So the scheme.
I mean, is it aimed at promoting the social inclusion of people with disabilities, for example?
I don't think it's stated in those terms. We've set out in our case what the headline points in relation to the reform documents were, and that is our case at MS page 151. You'll see that it was formally launched, reform was formally launched in December 2010, that's paragraph 43. At paragraph 44, there's a summary of the position, and I can take you to the documents, and then a quote at 44 and 45 on page 152. Those quotes can be found in the original documents in tab 22, MS 742 and 745.
Well, the reason that I was asking is obviously that Mrs. Scott was placing a lot of emphasis, not so much on, she's not suggesting that the convention is part of UK law, clearly it isn't, but what she was suggesting was that the overall aim to which the United Kingdom has subscribed by its participation in that convention, was of social inclusion of people with disabilities. So I was wanting to see, it's fairly clear that part of the aim of the new scheme was to reduce expenditure and to target assistance more carefully, while at the same time simplifying things. So there's a lot of references to simplification and making it straightforward to administer and easier and clearer to understand. That's in the command paper in 2011, paragraph 48. But there's also identifies those most in need of extra support to live independently and participate in everyday life. So we are talking about social inclusion here. Yes.
And that's right. I mean, you said that part of the, and indeed as the respondent has said, that part of the impetus was in relation to financial matters, and it was to ensure the long-term sustainability of the benefit, and to do so by focusing the benefit on those with the greatest need. And I don't think it's uncontroversial. I think it's uncontroversial, rather, to say that in practice and by design, PIP supports many more people whose impairment results from mental health conditions than the previous DLA did. Yeah, that's right. So that's what I wanted to say briefly about. The UN CRPD. The UN report is not referred to in the written case anywhere. It was put in, the response was not included either, but in any event, in my respectful submission, it's irrelevant to the question of construction. Insofar as Tom and Elizabeth are concerned, the last examples that Mr. Drabble took you to, these are examples of what a case might look like. And it's clear that just on the face of the information that you have, that Tom and Elizabeth have different needs and different levels of need. And that's all it is. It's an illustration of what a 9C case might look like and what a 9B case might look like. Finally, in respect of timing, the sporting analogy we respectfully submit is not actually helpful. And the concern is that what the Court of Session has said is much too broad and much too wide, and our primary position is that it must be contemporaneous for at least part of the activity, for all the reasons that we've given before and set out in writing.
So I think the Court of Session lifted it from an upper tribunal case, did they?
They did, yes.
It's paragraph 51.
Yes. And
It cannot be temporal or causal, because if there wasn't a causal link, some link in terms of time would be completely irrelevant.
well, not only can it not be temporal or causal, but also temporal and causal connection or link, whichever it is that.
So that doesn't give you enough guidance, because that
it's
could be any
much
length
too
of time.
broad and leads to arbitrariness and problems. And then when you take into account the fact that every other form of therapy and indeed communication support as well has to be either other therapy providing in advance doesn't count in the sense that it doesn't impact on the descriptors, or in the case of communication support, it's obviously got to be given at the time of the activity by the nature of its description. It places this kind of support completely out on a limb in a way that we submit could not have been intended, was not intended if you look at the background documents, and creates a host of difficulties.
I don't think there are any more questions. Thank you very much indeed, Ms Broadfoot, and thank you to everybody for their submissions and for doing the piece of homework that we asked you to do this morning, which I think has been very helpful, at least to us, in clarifying the nature of the disagreements between you. And we will now go away and work out how they should be resolved and let you know in the usual way. Thank you all very much.